got a meeting in Heber City with a client at their commission meeting. So, okay, we're live, we're ready to go. Should we do it? 5 o'clock. All right, welcome to the Morgan County Commission meeting. Today is January 2nd, 2024. We are beginning our regularly scheduled meeting. We'll start with an invocation and Pledge of Allegiance, and I've asked Commissioner Wilson to handle that.
Our Father in heaven, we come before Thee at this time, and we're grateful for this new year. We're thankful, Heavenly Father, for the things that we were able to accomplish in the year of 2023, and we're grateful for our community and ask that Thy blessings will be upon each and every one of us. We pray, Father in heaven, for our leaders of our nation and those who are at war right now. We ask Thee to watch over and protect them. We pray, Heavenly Father, that Thou will bless those who are involved in those conflicts, who are innocent, and ask Thee to comfort them in this time. We are grateful for this valley in which we live. We pray, Heavenly Father, that we can have Thy Spirit as we go about Thy business this evening, that we can make good decisions that will help our community and help the members of our community. And we say these things humbly. In Jesus Christ's name, amen.
Amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Commissioner Wilson. Okay, first meeting of the year, we get to take care of a little bit of business here regarding our assignments in the commission. So we will begin with the selection of the Morgan County Commission Chair and Vice Chair, and then we'll move into discussion and selection on Morgan County Commission portfolio assignments. So with that, let's open the floor for nominations for Chair. We'll vote on that and then open nominations for Vice Chair. Does that sound good? Okay, perfect. The floor is yours.
I just want
I'll make a motion that we leave it the same, both.
Okay,
And I'll second that.
we have a motion and a second. Are there any other nominees? Okay, seeing none, we'll look for a motion, a vote on the motion. All those in favor of
Aye.
continuing with Mike Newton as Commission Chair and Blaine Fackrell as Commission Vice Chair? All those in favor?
Aye.
Aye.
Any opposed? Okay, motion passes. Thank you. We'll now discuss portfolio assignments. Are there any discussions or questions, any changes you'd like to make on portfolio assignments?
I don't have any.
I don't either.
I don't either. I think we're all pretty comfortable where we're at right now, and that's great. So appreciate all the work that everybody does on each of their assignments. I know there's a lot going on. I think for the benefit of the public, what you see in this meeting is a fraction of the time that the commission spends working for the county. Most of the time is spent outside of this meeting in other meetings and other boards and phone calls and emails and other things. So our portfolio assignments are really important, and that's really where the vast majority of our work happens. So we appreciate the work that goes into that. So I think I don't know that we need a motion on that. We're leaving them the same.
I
Should we
don't
make a
know.
motion? Let's make a motion.
We can make a motion. The only question I have is I know Jared, I don't know if Jared's talked to you or not. I know last year he wanted to give up an assignment. I don't know if anybody wants to take that one off.
He hasn't mentioned that. Let's leave it
Let's
the
leave it
same, and
as
we
it
can
is.
change it next meeting if he wants to.
Well, it'd be a month from now.
But yeah, that's fine.
That's fine with me.
You good with that?
I'm fine with that.
Okay. So let's just have a motion then on number 5 here to leave the commission portfolio assignments as is for the time being.
So moved.
Second.
Okay, we have a motion and a second. All those in favor?
Aye.
Aye.
Any opposed? Okay, motion passes. All right. Item B, under consent items, is the signing official signing of any conflict of interest forms. So just for information of the public, the county commissioners will note any conflicts of interest that they may have. This could include ownership in a company that may do dealings with the county, et cetera. We'll list those here. That doesn't mean that we may not have other conflicts that come up at a later point. You'll notice that we have that opportunity to declare that each meeting, and so we would declare that at that time, but this is just the official form for the year that we fill out and sign each year. So I'll give each commissioner just a moment to fill that out, and we'll sign it officially and hand those in. We'll get the other forms from the other two at the next meeting that they're available.
And they don't have to be notarized this time, is that correct?
Correct. There's no
Okay.
notarization here.
Just wanted to make sure. I've already turned mine in.
Look at you. Okay.
All eyes are on you, Ron.
Okay. Perfect. We move to item C, which is our declarations of conflict of interest. Are there any conflicts with any agenda items on this evening's agenda?
None.
Okay, seeing none, we will move to our public comment period. This is an opportunity for the public to address the commission. We'd ask that you please limit any comments to 3 minutes or less.
Come on, Tina.
Okay, seeing no public comment, we'll move to presentations.
You think that's a sign of 2024?
Okay. So this evening's presentation is going to be just a brief presentation on the current lawsuits that are happening with the county. The intent is just for information purposes here. We're not here to discuss the merits of the case or anything. We're just going to talk about where we're at with the case, and we'll go from there. So I'll turn the time over to Mr. Smith, our county attorney, to give this presentation.
All right, thanks. So, and this is specific to the Croft versus Morgan cases. There's 3 separate cases going on right now, and I think there's a lot of confusion probably in the county building and in the community of which case is which, and where each is at. So as I go through, there we go. So in this slideshow, they're all Croft versus Morgan, but I've included the case number so that everyone can look it up. It's all public record. But then I've also called them first, second, and third lawsuits just for ease of identification. So this first lawsuit, it began back in 2019. So November 27th is when the petitioners filed their petition. And they initially named Morgan County and then also Stacey Netz Clark, who was the former county clerk, solely in her official capacity as the respondents to that case. They had 3 causes of action. The first was related to Article 6 of the Constitution, the Utah Constitution, and that deals with the right to refer a decision to the people for vote. Part of what the county has argued throughout is that Article 6 of the Constitution isn't triggered just by the filing of a referendum application, because it says that it has to be in the numbers, under the conditions, within the time frame, and in the manner as prescribed by statute. And so there is, Article 6 of the Utah Constitution doesn't outline the whole process for a referendum, and it defers some of that to the legislature. And so initially, the former clerk had rejected the application for lack of certification and failure to attach a copy of the ordinance. And that was something that was required under the election code. And so that was the county's position going forward. This first cause of action is for a violation of Article 6, and the requested relief was that the court issue an order to place the zoning ordinance on the ballot. One of the arguments that I made during trial was that the requested relief is something, they're requesting something illegal because it doesn't get placed on the ballot until they gather signatures, and those signatures are certified and so on and so forth. And so really what they were requesting is that the referendum move forward, but that's not how it was articulated in their petition. The second cause of action was for the violation of the election code, which is 20A-7, and and what's contained in that entire part, I guess. They initially outlined 607. I think they were meaning a different section, but basically they were saying they wanted an order from the court to accept the referendum application and place the zoning ordinance on the ballot. Once again, that's premature. If the application is deemed sufficient, then they would still have to go gather signatures. The third cause of action was for denial of due process rights under the United States Constitution and Code. Sometimes it's called a 1983 action, and they were requesting that the ordinance be placed on the ballot and award attorney's fees under Section 1988. So those are federal claims, and they're entitled to attorney's fees under that federal section as well if they prevail on that claim. So that's going back to the initial complaint, November of 2019. If we fast forward to April 6, 2020, that's when the court issued an order granting the motion to dismiss for lack of jurisdiction and final judgment. And that was based upon the statute itself saying that you have to appeal this directly to the Supreme Court, or you can appeal it to the district court if you're not prohibited, or if you're prohibited from appealing it to the Supreme Court. Supreme Court didn't like the legislature making them take those cases, I guess, and so they said, even though that's what the statute says, well, I guess I'm jumping ahead. So they filed a notice of appeal with the Utah Supreme Court, and then on August 12th, 2021, so now we're over a year after that notice of appeal, the Utah Supreme Court issued a ruling reversing the district court's dismissal and then remanding it to the district court for further proceedings, and they say, no, district court, you do have jurisdiction and we want you to hear this case instead of us. So from that point until April of 2023, there were a lot of just various motions and hearings that were held, but an in-person bench trial was scheduled April 19th to the 21st of 2023. Prior to the bench trial, February 8th of 2023, the petitioners, they filed a motion for preliminary injunction requesting certain relief that we'll talk a little bit more about in the third lawsuit. But the county filed an opposition on February 22nd of this year. No, last year, I guess, technically now, right? So February of 2023. And then on March 3rd of 2023, the court had a hearing where we were present in person, and it found that it had not received any evidence of harm being imposed on petitioners, and the court denied the motion for preliminary injunction. That order was entered May 1st of 2023. On April 18th, 2023, Morgan County, jointly with Wasatch Peaks as the intervener in the first lawsuit, filed a Rule 25D motion. And basically what the Utah Rule of Civil Procedure 25D says is that if a public officer is a party to an action, and during the pendency of that action they cease to hold office, whether it's death, resignation, or not being elected or whatever reason, there is, under the rule, a 6-month deadline to substitute a party. So Stacy left office in January of 2022, so the deadline for the petitioners to substitute Leslie in as the current clerk was July of 2022. this was filed right before trial because it came to my attention, I believe, on April 17th is when it came to my attention. I started researching it. I'm like, I need to file something because I think there may not be subject matter jurisdiction or jurisdiction of the court over the correct party. But the court did allow the parties to brief this issue further even after the trial took place, and ultimately determined that petitioners were not required to substitute a party under the rule. I did make a note there that I wanted to address the practical considerations. The county's argument for this is when someone sues a respondent or defendant, the court has to have jurisdiction over that defendant to order them to do anything. And they didn't sue the Morgan County clerk, they sued Stacy Netz Clark solely in her official capacity as the Morgan County clerk. And so the practical barrier of the court ordering the current clerk to move the referendum process forward is, since Stacy was no longer in her capacity, she wouldn't have the statutory authority to proceed with the referendum application. The county commission is the representative body for Morgan County as a whole, and so technically you're all being sued when they sue the county because you're the ones that the court has jurisdiction over. But once again, the county commission also does not have any statutory authority to move a referendum petition forward. So the chair is empty, or I mean, the chair is not empty, it's filled by Leslie now, but the court doesn't have jurisdiction over Leslie. So that's the basis for substituting a party. The court relied upon the Mowdy decision that involved the Sandy City Recorder in finding, in ruling that it wasn't necessary to substitute a party. However, this is now an issue on appeal for the Supreme Court because a city is different than a county, because in a city, a recorder is appointed by the mayor or the county council. And so if the city is ordered to do something, then the person that has authority over the recorder can order them to do something. But in a county government, the clerk is elected, and so the commission can't order Leslie to do anything, or the court can't, by virtue of the commission, order Leslie to do something because she's an independent elected official. So I know I'm kind of getting into the nuance, but that was the reason for that motion. The bench trial was conducted April 19th to the 21st of 2023, and I thought I'd summarize that Morgan County's main points during the closing argument were related to petitioners' failure to meet the minimum statutory requirements to trigger their right to referendum, and also that the notary was disqualified from performing a notarial act relating to a document that she's either a signer of or named in. With regard to the statutory requirements, there were also arguments made that it wasn't turned in on time, and also that, let's see, I don't know, maybe that was the other one. The certification issue had been previously resolved. So there were also arguments on the timing. The county, just because we couldn't prove one way or the other, dealt with the ordinance because it was admitted that it wasn't attached. And the argument is that attaching a copy of the ordinance isn't an arbitrary rule, that we're just saying, hey, jump through this hoop because the statute says you need to jump through the hoop. There's a practical reason that it needs to be attached, and that reason is that the election code official under the clerk's office has to prepare a voter information packet that goes to all of the voters so that they can be informed on what the decision was and arguments for and against that decision that the prior council made. If you don't attach a copy of the ordinance, then the public aren't going to be informed on what they're voting on. And so when the clerk and the election code official can't just go and put whatever they want into a voter information pamphlet. It's only what's allowed by statute. And the statute says you can add the referendum application, which is going to have a copy of the ordinance if it's submitted correctly under the county's position, and the arguments that are made by the sponsors in the county. That's all that goes into the voter information pamphlet. And so if the petitioners fail to attach a copy of the ordinance, then it doesn't go in the packet and the people aren't fully informed about what they're even voting on. So it's not an arbitrary rule. The county's position is that that's an important rule to inform the public of what they're voting for, and the public policy of that is we want an informed voting body. So the second aspect was an issue with the notary, and notarizations in Utah, it's a way to verify identity and avoid potential conflicts of interest. The Utah Public Notary Act, it disqualifies a notary from performing a notarial act if they're a signer of the document or named in the document to be signed. And the argument that the county made was that it's inappropriate to use an illegal notarization to facilitate a legal referendum process. And that, when you make an exception to any rule where there's no existing exception in the rule itself, then it doesn't support that rule of law to give certainty to elected bodies, to citizens, to anyone. And so kind of goes back to the mantra that I repeat often in these meetings, is that I think we need to comply with the code or change it. And there's ways that we can change our code, and if for some reason the Utah Public Notary Act is to be found wanting for some reason, then it can be changed. However, I think there is a public policy at the state legislature that they want notaries to follow the rules that are set forth. So with the first lawsuit, on September 15th, 2023, the court issued a memorandum decision and order that we just call the final judgment. And first, the court found that the referendum petition was sufficient and directed that the referendum process proceed as outlined in statute. And so the court didn't specifically order Morgan County, Leslie, or anyone in particular, just said, let's go back to the statute itself. In that order, the court specifically indicated that the final judgment was the final order of the court in that matter, and that no further things needed to be submitted, which, if we look at the causes of action, that third cause of action for the federal claims for denial of due process and attorney's fees was dismissed by the court. Despite that, the petitioners, they did submit a Rule 73 motion for award of attorney's fees against the county. On that same day, September 29th, 2023, respondents filed a notice of appeal with the Utah Supreme Court. And the Utah Supreme Court, they received the record on appeal because it doesn't go to them immediately. There has to be transcripts of all the court proceedings. It's a lot of work, especially when I think I looked and there's 500 different docket numbers of things that have been filed. So that's a lot of work to pull that information together. So eventually the Supreme Court received all of that, and they sent out a notice and briefing schedule to the county that our initial brief was going to be due on January 29th of this year. Shortly after that went out, the petitioners informed the court that they still had this motion for attorney's fees pending, and the Supreme Court elected to suspend the briefing schedule pending the resolution of the motion for attorney's fees. Currently, that motion is not scheduled for hearing until April 10th, 2024. And so Wasatch Peaks, they filed a motion and request to expedite consideration of all the pending motions. The day after they filed their motion, the petitioners filed an opposition to the motion to expedite. And so currently, it's still scheduled for April of this year. Just as a side note, the county believes that the motion for attorney's fees will be denied because the court already dismissed their third cause of action that was specifically requesting attorney's fees. But in addition to that, the petitioners are using a 20-year-old rule for their affidavits and a 15-year-old doctrine that's been disavowed by the state legislature. They're trying to argue that the state legislature disavowing the private attorney general doctrine is unconstitutional. So I guess we'll see how that's handled by the court when we hear that motion for attorney's fees. I've gotten a lot of questions about what the attorney's fees are, and so I thought I'd just outline them in this slide. But the request for attorney's fees totals $202,000, $601.25, and that's only for the first lawsuit so far. They have requested attorney's fees in all 3 lawsuits, but this is as of September 15th, 2023, what they're requesting. You can see the breakdown there. Dana Farmer, his total billing is $110,371. He billed at a rate of $370 an hour in 2022, and then it increased to $390 an hour in 2023. Darren Hammond, his total billing was $56,955.75, billing at a rate of $285 an hour in 2022 and prior, I guess I should say, and $300 an hour 2023 forward. Troy Boer, he handled the appeal to the Utah Supreme Court, and he charged a total of $24,630. He billed at $300 an hour, but he also had other associates working on the case, and they billed at $200 an hour. And then Richard Reeve was the initial attorney for the petitioners in the case, and he charged a total of $10,644.50, billing at $240 an hour. So that's the breakdown, how we get to that total number of just over 200,000. All right, so that's the first lawsuit. I apologize. I don't know if you want me to go faster or if you have questions. I'm happy to answer those. But these next ones will go a little bit quicker. So Croft versus Morgan, you can see that case number looks a little different. That's because it's the federal lawsuit, or what I'll call the second lawsuit. So the plaintiffs, they initially filed this lawsuit against the county in the district court, but they were alleging a federal violation of law, and so it was removed to the federal district court. And the initial, I don't have the exact date, I think they filed it mid-October. And so, yeah, I'll just say mid-October. They amended that complaint November 16th of 2023. And in their amended complaint, their first cause of action was for denial of equal protection rights under the 14th Amendment and United States Code Title 42, 1983. So once again, another Section 80, 1983 claim. And they were requesting that the court award damages in an amount, whatever they could prove at trial, and they wanted their attorney's fees under Section 1988 again. So on November 30th, Morgan County filed a motion to dismiss the plaintiff's complaint. Last week, plaintiff's response to our motion to dismiss was due, and they requested a 30-day extension to respond, and Morgan County granted that. So now their new deadline to respond is January 29th, 2024. And at that point, we'll respond to them and then see where the federal case goes. The basis for our motion to dismiss was claim preclusion. It's saying, you know, this has already been dismissed at the state level for a 1983 claim, and so we think it's inappropriate that you're repurposing and repackaging this to sue us again. Lacking subject matter jurisdiction over the claim itself failure to state a claim upon which relief can be granted. They're alleging that the county is conspiring with WPR or coming up with this scheme to reject applications for projects that we want to move forward and accept referendum applications for projects that we don't want to go forward. And as you're aware, there were 2 other referenda filed last year, and it's kind of interesting to say, well, this is, this scheme, why you're rejecting it when the commission passed both of those. And so if we didn't want them to move forward, we probably wouldn't have passed, or the commission wouldn't have passed it to begin with. And we think that a much better explanation for why we accepted the 2 referenda filed in 2023 was because they attached a copy of the ordinance and they didn't have a disqualified notary. And so it's not based on whether we like the project or not, but whether they complied with the code or not. So, all right. And then now this is the 3rd lawsuit, and it was filed November 17th, 2023. Morgan County was named as a defendant once again. The first cause of action was for injunctive enforcement relief under Utah Code Annotated 1727A-802. That's the land use and or LUDMA. You've probably heard that before, CLUDMA for the counties. And they were wanting injunctive relief on these land use decisions going back past the typical 30-day deadline to challenge any land use decision, which they hadn't done for anything, but they went back to the beginning up until what had been passed at that time, which was the October 3rd meeting, where the commission passed a plat that was already through the vesting process. And I know that we had talked about that somewhat extensively at that meeting, where the county's position was, because of the September 15th ruling of the court, the county won't be accepting any new applications, but anything that was vested prior to that decision would move forward under the vested rights doctrine and CLUDMA, right, the land use. So that was their first cause of action. The second cause of action was for a declaratory judgment under Utah law. They didn't specify which law they were seeking that under. And then just kind of FYI, December 13th, 2023, after the TRO hearing, they amended their complaint to add the request for attorney's fees. I had a call from a resident asking whether they were requesting attorney's fees against the county because they heard that they weren't. And I said, no, it's been part of all 3 lawsuits. So same day they filed their complaint, they also filed the motion for preliminary injunction and temporary restraining order. They served the complaint the following week. A week after they served the complaint, they filed a proposed temporary restraining order. And then just a couple days later, 3 days later, the court issued that temporary restraining order. They set a hearing for the court to consider the preliminary injunction for December 6, 2023. A temporary restraining order by law can only be in effect for 14 days, and so that's why they were requesting that initially. A preliminary injunction can be more permanent or long-lasting. Let's see, the preliminary injunction hearing was held on December 6th. We had quite a packed courtroom, so I know some of you were present all day to hear some of those arguments, but there was different evidence presented, mainly by proffer by the parties. There were arguments made, but ultimately the court issued a ruling entering the preliminary injunction, and it had the same terms as the temporary restraining order. And that preliminary injunction was issued by the court, signed by the judge on December 14th, 2023. Also on that same day, the parties, we met with the court by telephone conference, and under the rules, the court could make a preliminary injunction a final order if it addressed the causes of action that had been presented. And so rather than having to set a new trial and going through the same arguments with the same judge who would likely issue the same ruling, the court said that we can just enter this preliminary injunction order as the final judgment for the third lawsuit. So on December 28th, 2023, the court issued a final judgment. And then that same day, Morgan County filed a notice of appeal with the Utah Supreme Court. December 29th, Utah Supreme Court sent a notice that they received our appeal and assigned a case number. And the current deadline for the county right now is on January 18th, 2024. We have to file a docketing statement with the Supreme Court. But they'll also have to receive the record on appeal, transcripts and so on and so forth. And once that's received by the Supreme Court, they'll set a briefing schedule. Fortunately, this case only has like 130 docket numbers rather than 500, and so I'd imagine that the transcripts and everything won't take quite as long to pull together as in the first lawsuit. And I believe that's all I put up on there for the presentation. So I don't know if there's any questions, but
I just, on lawsuit 2, I didn't see.
sure.
I didn't see where that was, the hearing was for that. Is that?
So a hearing hasn't been set. They requested a 30-day extension because they had a deadline last week, but as a general rule, professional courtesy, you want to agree to extensions as much as you can. So their new deadline is January 29th of this year.
Thank you, Garrett. That's very informative and helpful. I think it's helpful for the public to understand what the county is doing currently in terms of these lawsuits. Okay, let's move to action items. So we'll start with action item F1. This is a resolution approving the schedule for our 2024 meetings.
I have a question on one. Let me get to it. In October, towards October and September, it has budgeting in October. We need to make sure that's changed to September.
So I made a note that it's correct on page 18, because I think we had circulated this and made those corrections. So it's correct on page 18 of the packet. And if we could just reflect that on page 16, because it also says September 20th, which is a Friday. So the meeting would be September 17th, and then the budget work sessions would just be bumped above September and say September and October. But that is reflected on page 18 of the packet.
Yeah, because I saw that as being contradictory, so.
We need to get that corrected before we sign
Yeah.
this.
We need to get it corrected.
Any other comments or concerns?
But basically on 18, you have the commission for the calendar year as follows, but on the page above that, so where it says budget work sessions, we're going to correct that to be September. Is that correct? Not
Right.
October.
So on page 18, budget work sessions is put above the September dates, and it includes September and October, and September 3rd and 17th instead of September 3rd and 20th. And so if the changes that were made to page 18 can be reflected on page 16, I think it'll be consistent.
Okay,
Agreed.
okay, and I didn't see a problem with any others.
Okay. That will look for a motion then to approve as amended this evening.
I move to approve approve the schedule of the Morgan County Commissions for the year 2024, Resolution CR-24-01, with the added revisions of the budget work session.
Second.
A motion and a second. All those in favor?
Aye.
Aye.
Any opposed?
Aye.
Thank you, Commissioner McConnell. Okay, motion passes. All right, we will move to action item F2. This is discussion decision ratification of a change for policy for extended vacation hours for certain circumstances. There was some back and forth discussion on this via email. Is there any additional discussion? This is a county administrative policy for vacation time for our employees.
No, I think everything
I
that
think
I
it's-
wanted, understood,
Been addressed.
is addressed, so.
Excellent. Okay, and we'll look for a motion to approve.
I move to approve the ratification of a change in the policy for extended vacation hours for certain circumstances.
Second.
A motion and a second. All those in favor?
Aye.
Any opposed?
Aye.
Motion passes and is unanimous. Action item number 3, Commissioner Fackrell.
Yes, I didn't know we were being put on the agenda, but I am requesting that we have Carver Floric and James Financial Accounting Services to do the normal reconciliation of our financial accounting for the county, which it should be pretty close to being done, according to Leslie, for the year 2024. Or no, to continue with the 2024, the way we have been doing it. And then the next section is to have them prepare stuff for the audit, so.
Okay, let's do this in 2 parts then. We'll do the,
So is the current one then going to be for 2025?
no, it should be
No, it should be
2024.
2024.
It's the monthly reconciliation and financial accounting is 2024, and then the audit is 2023.
Yeah, so it's to continue doing what we've been doing this year and the last year,
Okay.
to have them come and work with each of the departments, the treasurer and the clerk, to make sure that they have their financial accounting up to date every single month, instead of waiting like they did in the past, in our first year here. So it's to make sure that we keep things up to date,
Have
and
you
it has been
felt that
working.
was been good?
And of course, over time, it's gonna start
Get
saving
better
us
and
more
better.
money. Right, it should start saving us some more money. Yeah. Because she's getting better at it.
Less and less time.
And so's the treasurer, so. So that's what
In
I
the
would like to
past,
recommend.
Haven't they
So do we
submitted a
just pay
letter?
for that on a stated hourly rate?
They have not,
Well, in the past, we have done it based on an
Yes.
hourly rate. We
Yes.
just don't have the letter currently.
yeah, we don't have the current
So I
letter.
guess we're looking for approval to get that letter and
That's right.
sign based on the terms of that letter. Is that fair enough?
That's correct.
Okay.
So we're not approving a budget amount, we're approving that they make our.
To get an engagement letter.
Okay.
Yes. Is that okay, Robert?
So I'll make a motion that we approve an engagement letter, that getting an engagement letter with Carver Floric and James Financial Accounting Services to assist our clerks and financial for monthly basis and reconciliation of our financial accounting of the Morgan County for the year of 2024.
I'll second that.
So a motion and a second. All those in favor? Aye.
Aye.
Any opposed? Motion passes. Thank you. And then item number 4 is a continuation of this. This is regarding the 2023 audit and again, engaging for an engagement letter with Carver, Floric, and James to prepare that 2023 audit.
That is correct. And that's basically, last year was the first year we were able to get the audit done early fact, it was done before the due date. And so I'd like to try to achieve that a second year in a row if we could. And I think we're well on our way to getting that done, as long as everybody follows with the emails that Leslie sent out to make sure everything is in and submitted before the 16th of January for last year, for 2023. That way they can go about and do their work that they need to get done. So,
Okay,
do you have
I'll
a
make a
motion?
motion that we approve an engagement letter with Carver, Floric, and James Financial Accounting Services to prepare the financials for the 2023 audit.
I'll second it.
I have a motion and a second. All those in favor?
Just because we do this way.
Aye.
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 Any opposed?
You know,
Okay, motion passes.
I'm understanding.
Okay, that brings us to the end of our meeting agenda here. We just have the commissioner comment period. I'll just give an update. The Croydon Bridge project is on schedule, and the bridge is scheduled to open for one-way traffic. There'll be a signal on Monday, so this coming
Okay.
Monday, which is none too soon. So appreciate the work that's gone into that with the contractor and UDOT and their partnership with the county. This fall has gone very well. It can start snowing real hard after next week, as far as I'm concerned.
Well, it's supposed to.
So anyway, that's my report on that. I don't have any other items. Commission Vice Chair Fackrell.
Yes, along with that, a week from Saturday will be the first leg of the quad fishing tournament on, hopefully we get enough ice. And I don't know if there is. I know in my livestock watering tanks that we have quite a bit of ice, but hopefully on the lakes they get a little bit of ice for these quad tournaments, and the first one is on the 13th of January at Lost Creek. So it's a good timing for this thing to happen.
Yeah, that's great. The bridge is open in time.
And then the next one will come about on the 20th, but that'll be in Summit County. But it's 4 lakes. You got Lost Creek, Pineview, Echo, and East Canyon. So the first one's Morgan County, the last one is Morgan County in February. So anybody that wants to go fishing, I think there's a fee of $50. Take your kids, go do that. Helps out with tourism. Okay?
There's awards to be had too.
There is also, the grand prize, I think, is around $15,000.
Wow.
So,
If you got a fishing pole and an ice pick, you better get
From the
busy.
state?
no, these are from different businesses that have donated towards this.
Wow.
Some of it has been donated by some of the items donated through Summit County and our county is a lot of paraphernalia. So.
Swag.
Swag, as you call it, yeah. So, anyway, that's the main thing, and I just want to commend all of the employees of our county for this last year. It's been a great year, and I'm hoping this year is going to be a great year also. And that's about all I have for today.
Thank you, Commissioner Fackrell. Commissioner McConnell, do you have any comments?
I passed along by email a copy of some grant requests that we sent for the airport. I'll just keep you updated about that.
Awesome. Yeah, I saw that. That's wonderful. Hopefully, fingers crossed, those grants come through. Okay, Commissioner Wilson.
I would just ask the community, I've been in discussion with the different representatives from the different parks of our county, and there's a few items that they would like done, but if any of our residents understand or notice anything that needs done in one of our parks, get with me or the representative. So, that's it.
Awesome. Okay, with that, brings us to the end of our meeting. We'll look for a motion to adjourn.
Shortest meeting of the year.
Yeah, I'll commend you on your remarkable efficiency. I wish I was there instead of the one I'm at.
We hope that yours goes quickly too, Commissioner.
Motion to dismiss.
Just before you do that, though, we would like to have just a little, so Robert, if you're able to, stick around for an administrative meeting It's not a closed session, but just an administrative meeting after this meeting is ended.
Correct. Okay, we are adjourned.
Okay.
Thank you very
Okay.
much.